Hello, and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. We are talking about permissions to reapply to the United States after a deportation order, and sometimes people ask, well, what's included in it? Well, first of all, let me again strongly recommend you get an attorney who's knowledgeable in this area because if you're barred from coming into the United States because of a prior deportation order, the door to open for you is based upon this permission to reapply. If it's not approved, then no matter what else you have going for you and no matter what else you have approved, you're not coming in. So this is very important to get it right and as strong as possible. Generally speaking, when we do the permission to reapply, we of course have the form I-601, which is a waiver of anything else you might be inadmissible under. So let's say it's a criminal waiver or fraud waiver. So that goes along with the form I-601, and keeping in mind the form itself is just the form. There's lots of exhibits that are attached. Then we'll do, of course, form I-212, which is the permission to reapply and everything necessary for that. We'll do forms G325A for each person who's involved. If it's a marriage case, we'll get the marriage certificate, authenticated copy. We'll get the birth certificate, show the relation if it's not a marriage case, so forth. And then we'll have everything translated into English. We will have family members and relatives who are lawful permanent residents or U.S. citizens to show some hardship. We'll get a letter first from the applicant showing the reasons for which that applicant is requesting the waiver into the United States. And then we will get all kinds of character reference, moral references, religious, employment, all kinds of character letters. And people always ask me how many. I go, as many as you can get. You can get 50, give me 50. So there's no minimum. The more the better. And then we'll show hardship letters also from the client themselves, explaining extreme hardship not only to the U.S. citizen lawful permanent resident relatives if they exist, but also to the applicant herself or himself, which, unlike many other waivers, unfortunately, it doesn't matter. So with a permission to reapply, at least in that respect, the burden is a little better. And then, of course, we'll attach all the necessary evidence and exhibits and then submit it at that point. Okay, more in the coming videos.